history shows a history of violence. She had, starting in 2011, battery against a law enforcement officer.
Enjoy the video. Hit the like button.
All right, let's go on the record. This is in the District Court of Butler County, Kansas. Case is entitled...
Greenwood.
Did I say Butler?
Uh-huh.
Right, well, this is in the District Court of Greenwood County, Kansas. Case is entitled State of Kansas versus Bailey Cargile, case number 24 CR 61. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Your Honor, Mr. De Hoyo is here on behalf of Ms. Cargile, who also appears by Zoom in from the Greenwood County Jail.
All right, we are scheduled for sentencing today. Ms. Cargile entered a plea to a number of different charges back on January 2nd. There were some holdups in getting court records from other jurisdictions, perhaps a failure to appear, but I do have a PSI. And are the parties ready to proceed to sentencing today, Ms. Gillette?
State is, Your Honor.
And Mr. Hoyos?
Yes, sir.
All right. The PSI that I've received indicates a criminal history score of A. Ms. Gillette, any objection to the criminal history score?
No, Your Honor.
And Mr. De Hoyos?
Judge, two things. One, no objection. I've done my research on this and I think it is accurate. Can we take the Greenwood County Jail off of mute so that my client can participate? Thank you.
All right. So there's no objection from the defense to the criminal history score of A?
No, Judge.
All right. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing today?
No, Your Honor.
And Mr. De Hoyos, are you?
No, Judge.
All right. I did receive, and I've had an opportunity to review a motion for dispositional departure filed on behalf of the defense. I'd like to take that up first. Mr. De Hoyos, if you could make argument in your sentencing recommendations at this time.
So, Judge, two things here, or a few things here, rather. The motion is not just for a dispositional departure. In the event that you cannot find good reason to put somebody on probation in this matter, we're asking you to consider a durational departure down to 17 months incarceration. That reflects half of what we expected was going to be a B-box sentencing. It came out as A-box. Judge, I'm going to stress that when you go back through her criminal history, through Ms. Cargile's criminal history, I mean, you see that she was battling addiction. There's no question about that. And Ms. Cargile will tell you the same. She recently returned from Washington, having done something like 6 or 7 months incarceration there. Was brought here on a governor's warrant to answer for these matters. There was some confusion about when her original sentencing date was, and then when it was pushed back, when the next sentencing date was. And after talking with Ms. Cargile, she'll be able to expand more upon this. I don't think that she missed the court dates with any bad intention. I think that there was a significant miscommunication because of the way we had to bounce this thing around a couple of times. All that being said, Judge, I'll tell you right now, I don't know anybody who said, I went to prison to get sober. That's not a thing I think happens. I think that people can find sobriety when they're ready for it. And in this time that we're here meeting today, Ms. Cargile has more than 7 months of sobriety. This is the most sober she's been, I think, in her adult life. While she has been incarcerated for a significant portion of that, my point is very simple, is that by imposing a probation sentence today, we have the foundation laid for her to be successful in recovery. She's still very young. She can still become a very well-accomplished adult, become an active member and a contributing member of society. I do have full faith and credit that when she is sober, she's the kind of person we want her to be. And I think that if this court gives her that opportunity, the kind of opportunity she has never received from any court in the United States, then she will demonstrate to you that with proper treatment and sobriety, she's awesome. She's great. Now, Judge, to that end, I've been working with Ms. Cargile since she got back in early December to set up treatment plans, to set up sober living environments, to set up more. She can expand upon that, but we have things arranged with Cornerstone. We have a drug and alcohol treatment evaluation lined up Judge, I mean, Miss Cargile is jumping through every hoop she can to demonstrate to you that she wants her life back in her hands, or she wants her life back in her hands, away from sobriety, or away from intoxication and back to sobriety. She's got a kid out there that she needs to go take care of. And ultimately, long-term, Judge, I don't think that the taxpayers of Greenwood County or the state of Kansas are made better by Ms. Cargile's incarceration. I think they're made better by a treatment plan, by Ms. Cargile going through the proper steps and embracing sobriety full-fledged. I think that she's bouncing off rock bottom right now, and we can either stunt that by throwing a rock against her and tying it to her ankle and throwing her in prison, or we can support that by giving her a shot on probation to demonstrate that she is who she says she is, and that she is becoming a woman that we want to have in our community. So for all these reasons, Judge, and again, I'm going to ask Ms. Cargill to expand upon it when you ask to speak to her. For all these reasons, I don't believe our society is better off with Ms. Cargill in prison. I don't. I think that she needs an opportunity of probation, the kind of opportunity she's never received from a court, and giving her that good grace one time might very well make all the difference for who she becomes.
All right. Thank you, Mr. De Hoyos. Ms. Gillette, if you could respond to the departure request and provide your recommendations.
Your Honor, Miss Cargile is presumptive prison. Miss Cargile has earned her criminal history. She's 34 years old and she's had 45 convictions. This case was committed while on felony bond out of Skagit County, Washington. She's gone back and forth between Washington and Kansas. She had a failure to appear, was not meaningfully participating for her pre-sentence investigation. We brought her back on a governor's warrant. She finally signed her extradition on the 13th of November. The governor's warrant was obtained on November 9th. She had to be brought back. There is a transport cost. We're going to be asking for restitution of $4,108.77 to have her transported back from the state of Washington. This case, as I said, was committed while on felony bond. That's one of the cases she was arrested for out there while she was in Washington.
Ms. Gillette, I don't see a special rule marked indicating she was on.
If you look at the original PSI that was filed April 16th, 2025, or it was submitted April 16th, 2025, it is marked there. Crime committed while on felony bond, Skagit County, Washington, 23-1-0037229. That
So
case.
I'm looking at a PSI I received, I believe earlier this week.
Yes, they changed it from the one that was submitted in April to the one that was submitted in December. That special rule was not put on the new one, but it was on the original one.
Well, is it supposed to be in effect?
It should be in effect.
Judge, if I may here,
Go ahead.
two things. As I understand it, and Ms. Cargill, I have to make sure I got this straight. I think that the case that she was on bond for was ultimately dismissed. But more than that, Judge, by law, I do think it would be accurate that special rule would be marked. That's just an operation of law as opposed to the merits because the case was dismissed.
Yes, Your Honor.
All right. Ms. Terrones, are you here from Court Services?
I am, Your Honor, and that is correct. Christine said she took it off because that case was dismissed.
All right. So it has no functional application because there'd be nothing to run it consecutive to.
Correct.
I understand that. Okay. Go ahead, Ms. Gillette.
In addition to that, Miss Cargile might have been battling addiction, but her criminal history shows a history of violence. She had, starting in 2011, battery against a law enforcement officer, interference with a law enforcement officer, another battery in 2021, or that was her conviction date. That was a 2012 case. As you go on through, number 16 is battery of a law enforcement officer. As you move on down, she has endangering a child. She has assault and battery with a dangerous weapon, driving under the influence of drugs, resisting an officer, leaving the scene of a collision involving damage, obstructing for an officer. She has reckless driving. She has driving under the influence several times, simple assault, which were her most recent convictions while she was out in Whatcom County, Washington, where she had last been housed before being brought back to Kansas. Her current crimes of conviction is possession of methamphetamine, felony fleeing an officer, battery against a law enforcement officer, driving under the influence, and reckless driving. These all are serious things that she fled in a vehicle from an officer. She's a public safety risk, not once, but twice on her convictions. She puts the entire population at risk when she is running from officers. Not only that, but she actually harmed an officer in this case by causing a car accident where she slammed on her brakes and made the officer hit the vehicle that she was in. And not only did she flee, she ended up going onto roads down into all the way into other counties. She has caused all kinds of mayhem and problems through multiple states. And we had to go get her. And so I do not believe that Miss Cargile has earned the right to be among the general population. I believe that she warrants going to prison. This is not a case where the state is in agreement. I actually considered filing a motion for an aggravated sentence. I did not, mostly because I talked to Mr. De Hoyos. The state is going to be recommending the standard term of 40 months for Ms. Cargile. We are going to be recommending the up to 20% good time credit on count 1. 12 months post-release. She has jail credit that needs to be awarded to her of, I believe, 99 days. No contact with her co-defendant. Her sentencing has had to be moved numerous times due to her failure to appear and us having to drag her back from Washington County. Fleeing an attempt to elude a law enforcement officer, we are recommending the standard 6 months, up to 20% good time credit, and 12 months post-release. Battery against a law enforcement officer, we are recommending the 12-month sentence. Driving under the influence, 6 months. And the reckless driving, it is an unclassified misdemeanor. It has a range of 5 to 90 days based on the statute. We are recommending the 90 days. I will recommend that they be concurrent. I considered asking for consecutive based on her criminal history and behavior. But I will recommend them to run concurrent. She has court cost of $193, a $400 KBI lab fee. She's already on file with the state of Kansas, so there's no DNA fee. We are recommending her $45 booking and fingerprint fee and restitution to the citizens of Greenwood County for $4,108.77 for her transport cost for bringing her back here. It is her choice to take advantage of the programs that we have here in the state of Kansas at KDOC. Those programs that she can take advantage of would give her program credit. But the state is not recommending any kind of departure for Ms. Argyle.
All right, thank you, Ms. Gillette. Mr. De Hoyos, anything else as far as sentencing recommendations?
Two things, Judge. Briefly, she can't pay back the people of Greenwood County if she's incarcerated. $5 an hour is what they pay in prison, and Lord help me, I don't know how many hours it is, but it would be, she doesn't sleep a moment she works at all. But also, we're talking about somebody who's here by criminal history A on converted misdemeanors. She is not a true criminal history A. She is here by way of converted misdemeanors. So I don't think I have to go about telling you how many terrible people I've represented in my career, but this isn't one of them. There really isn't, Judge. I think she needs a chance of sobriety. Keep in mind, she was incarcerated for like 6 or 7 months before now. She's not going to get credit for it because the case in Washington was dismissed. So if you're looking for somebody to have a sober foundation and a future that you might be able to witness with probation, Ms. Cargile's the right candidate.
So she's never had an opportunity to complete treatment during the course of any of these cases?
So, Judge, I think it's saying too much to say that she never had the opportunity to complete treatment. I mean, she could have always sought treatment if she had come to that term herself, right? But the court has never ordered her into treatment in any of these cases.
All right. Thank you, Mr. De Hoyos. Ms. Cargile, is there anything that you would like to say before the court pronounces sentence?
Your Honor, I have struggled with addiction for more than all my adult life. I know I have made several bad decisions and that I was wrong for that. The day that I caught this case, we'd been on the road for 3 days. We were headed to my father's funeral. When I got stopped, I know I should have handled it differently. I wish with everything I am that I would have. But just like the fear of missing his funeral and just the drugs and just everything, I just panicked. Over the last 1.5 years since I got out on bond, I did everything I could to make every single court date and comply with every request from the court. I know that my last court date, I did miss it. Your Honor, when you guys were going back and forth about the court date, I promise you I wrote down the wrong date. I wasn't going to be present in Greenwood, but I was going to appear on Zoom. When I realized that I missed it, I did reach out to my lawyer. I did turn myself in to Washington to address my issues. The only reason I requested a governor's warrant is just because I was advised by my lawyer to address those issues in Washington prior to coming here, just so it would be done. Those cases was like 3 years old. Since I have caught this case, I have not caught any other case, and I have addressed all my cases that I had before that, and got them all resolved. But due to me having a hold out of the state of Kansas, they didn't offer me any rehabilitation out of the state of Washington because of this case. And several years ago when I got in trouble, that was the same case. I had a hold out of a different place. So every time I've been in trouble, that's why it just like last minute they made a deal and I wasn't able to receive rehabilitation ever. And I think that that would be life-changing at this point. I did a lot of things to turn my life around and like leave bad habits behind. I just think that if I could receive some help like with rehabilitation and get some skills to help me be successful in the world without, you know, when I go to prison, I get out and I feel more separated from everybody and different, and I don't have anything to stand on. And I want to be able to do something different. At this point, the only thing I fear is failing again. So I apologize to the court for missing my last sentencing, but before that, it was only put on hold because the DA asked for more time. But I do apologize for my part in missing my last one, and I hope the court will forgive me. And that's it. Thank you.
All right, thank you, Ms. Cargile. Counsel, what is the minimum statutory fine on a Class B DUI? Is that still?
$750, Your Honor.
All right, Ms. Cargile, for the primary offense of possession of methamphetamine, a level 5 drug felony with your criminal history score of A, I do sentence you to the standard mid-range term of 40 months with the Kansas Department of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. In count 2, for the offense of fleeing or attempting to elude a law enforcement officer, a level 9 person felony with criminal history score I do sentence you to the standard term of 6 months with the Department of Corrections. You are eligible for 20% good time credit, subject to 12 months post-release supervision. For the offense of battery against a law enforcement officer, the Class A misdemeanor, I do sentence you to 12 months in the Greenwood County Jail. For the offense of driving under the influence in count 7, the Class B non-person misdemeanor, I do sentence you to 6 months in the county jail and impose a $750 fine. For the offense of reckless driving in count 11, an unclassified misdemeanor, I do sentence you to 90 days in the Greenwood County Jail. The court has reviewed the motion for dispositional and durational departure and has listened to the arguments of counsel. I will note there is a special rule that applies that this is a third or subsequent felony drug possession and your criminal history, criminal history score A based on your prior criminal history. Ms. Cargile, going through this, you have 45 convictions. Starting back in 2005, yes, many of these are misdemeanors. There's your standard traffic, driving while suspended, MIPs, battery of law enforcement officer, interference with law enforcement officer, theft, battery, possession of drugs, theft, endangering a child, theft, assault and battery with a dangerous weapon, DUI, resisting arrest, leaving the scene of an accident, possession of forged notes and instruments, obstructing officer, criminal mischief with a deadly weapon, theft, simple assault. I find it hard to believe that during the course of all of those cases, especially the drug cases, that a court never ordered that you be evaluated and complete treatment. I suppose it's possible. However, you're almost 35 years old. You continue to commit crimes. At some point, somebody who was interested in getting sober and getting their life together, having children to support, would take that initiative themselves rather than continue to commit crime after crime after crime. This one, fleeing or attempting to elude a chase through Greenwood County, battery of a law enforcement officer while under the influence, getting out and running from the car, having to have drones or whatever they had to try to find you, you're a risk to the public, Miss Cargile. And I'm sorry if you have a substance abuse problem, but you don't seem like a person who's taken any steps to meaningfully address that, and you continue to commit crimes. You're a poster child for a criminal history score A presumptive prison case, whether they're all felonies or converted misdemeanors, it all adds up. And I'm not finding substantial and compelling reasons, so I am going to order or deny the request and follow the presumption of prison and place you in prison for 40 months. For count 2, you do have some jail credit of 99 days you'll have against that 40 months. I'll run the remaining counts concurrent with one another, so you'll have 40 months minus time served on this case. I'm going to order you pay the court costs in the case. Going to order you pay a $400 KBI lab fee for the testing of the drugs. I'm going to order you pay a $45 DNA fee, or booking fee rather. I'm going to order that you pay restitution for $4,108.77 for the costs of Greenwood County having to retrieve you from the state of Washington pursuant to State versus Robinson. And your period of incarceration and future incarceration, I will waive bids, application fee, and bids, attorney's fees. You may have a right to expunge some or all of these convictions at some point in the future after your sentence is completed and a couple of years have passed. You might look into that. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford to hire an attorney, one will be appointed for you. As a convicted felon, you can't possess firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. In case I didn't make it clear earlier, you do have 20% good time, eligible for 20% good time credit, and are subject to 12 months post-release supervision. Ms. Gillette, are there any sentencing related orders that you feel I failed to address?
Did you mention prohibition of firearm?
I did.
Okay. Remand to the sheriff for transportation, so will be all left.
Mr. De Hoyos, can you think of any sentencing related issues the court's failed to address?
Judge, the only concern I have really comes down to jail credit. I mean, if this case was pending during the time that she was held in Washington and you ran a concurrent to her Washington cases, there's an additional 6 or 7 months of incarceration credit she would receive, which otherwise I don't think goes anywhere because the case that she was being held on gets dismissed, or it was dismissed. So
That's true.
ultimately what we're talking about is giving her credit for the time she's been in custody.
She got credit for the Whatcom County, which was the last county she was in. Whatcom County is the last 2 convictions that had to be updated on the PSI, or last maybe 3. She had to have updated on the PSI.
Any credit that she legally has coming, she should get. This is what's been listed in the PSI. That amount wasn't contested earlier, so this is what the court's ordered. If there's additional time that she should have credit for, it'll need to be brought before the court elsewhere, but that wasn't done, so that's what I'm ordering based on the information I have here in the PSI.
Judge, I guess it just begs the question, is this concurrent or consecutive to previous cases?
Well, there's there's no special rule requiring it to run consecutive to anything else. I haven't ordered it to run consecutive to other cases.
Thank you, Your Honor.
So, all right, Ms. Cargile, do you have a question?
Yes, Your Honor. So does that mean since I've been incarcerated since July 8th that I know that my case is out of Whatcom that I did handle on the paperwork there, it said would run concurrent to anything else. But after that, I was in Skagit County for like about the last 4 months. But I've been completely incarcerated since July 8th. So I will get credit for that?
I've given you credit for the days that are set forth in the PSI, which total 99 days. I don't know if that encompasses some of the dates you're referring to or not.
All right, I'll check with my lawyer and maybe call my other lawyer and see if I can get the exact dates and submit them to my lawyer, if that's okay.
All right, Ms. Cargile, I encourage you to take advantage of any treatment programs or other programs that may be available to you in the Department of Corrections if you do truly wish to be out and be a productive member of society.
Yes, Your Honor.
At this time, I'll direct that you remain in custody until transportation can be made arranged to take you to the Department of Corrections.
Thank you, Your Honor.
All right, if there's nothing further, we'll be in recess on the Bailey Cargile matter. Thank you.
Thank you, Your Honor.
Thank you, Mr. Doyos.
Judge, I think that's the only thing I have this morning. Am I free to go?
You are. Have a Merry Christmas.